Welcome to Group 58's presentation. My name is Robin and I'll be presenting to you today. Our presentation will examine Apple versus Samsung's negotiations that took place between 2011 and 2016. I will start off by taking you through the events that led up to this negotiation. Apple is a multinational technology company known around the globe for its products in design, electronics and online services. However, the world-renowned firm also has a reputation of sharing ongoing disputes with other multinationals. In May 2012, the CEO of Apple, Tim Cook, went against Samsung CEO Ji-Sung Choi in the U.S. District Court of Northern California to achieve an agreement regarding a patent case. Apple had also filed other similar suits against countries such as the UK, Japan and Germany. In April 2011, Apple filed a lawsuit against Samsung claiming that they had copied their iPhone products in terms of the look and feel with their Galaxy range of phones. In this lawsuit, Apple accused Samsung of infringing 8 utility patents, 7 design patents, and 6 trade dress rights. Samsung counteracted by stating that Apple did not pay royalties for using its wireless transmission technology. As a result, the number of patents has increased immensely. The disputes expanded to over 50 lawsuits across the world and became known as the patent war. The two firms have been at war for a long time over efforts to clone each other's smartphones and other gadgets. After some encouragement by the court to attempt mediation, Apple then filed a motion demanding that Samsung's Galaxy Tab 10.0 should be barred, stating that the product was simply mirroring Apple's iPad. One aspect shared by both firms was the wish to avoid official legal battle if possible. Apple understood Samsung was a major supplier for them, which fueled their commitment to settle the conflict amicably. This resulted in a 2-day mediation phase between the CEOs in May, but concluded with an impasse as both firms could not reach an agreement and refused to cooperate. As a result, the case went on to trial twice, in which Apple has won over $500 million. Preparation lays the foundation for a successful negotiation. According to Thompson, the 80-20 rule applies to negotiation whereby approximately 80% of effort should go towards preparations and the other 20% should go towards the negotiation itself. This rhetoric portrays the sheer importance of preparation. The two parties, Apple and Samsung, displayed interest in compromising to avoid court by cutting the number of disputed patents in half, though their mindsets prepared them for attack and not compromise. Apple took a particularly defensive stance, with Steve Jobs being quoted, "I'm going to destroy Android because it's a stolen product." Effective preparation for negotiation requires evaluation of 3 general topics. These include self-assessment, other assessment, and situation assessment. First comes self-assessment. From the general view of both parties, they had to identify their objectives, their BATNA, their target, as well as reservation points. This process requires parties to ask themselves, what do I want? Assessing risk propensity is essential. Negotiations between Samsung and Apple exposed both parties to a lot of risk due to the legal nature of the dispute, with a significant amount of money at stake, which ended up amounting to more than $409 million following 2 trials. Sunk costs were expected to be high due to the resources involved in legal battles. Ultimately, time was a huge cost, which ended up amounting to over 7 years, and this cost prevented Apple from pursuing other disputes. Secondly, other assessment. Both Samsung and Apple had to identify the counterparties' interests and positions by asking the question, who are the other parties? Samsung must have considered that the US court ruling may be more favourable towards Apple due to the perceived home country advantage. Third is situation assessment. This process required Samsung and Apple to evaluate the situation more generally. It prompted them to consider their relationship, whether scarce resources are targeted, if the negotiation is transactional and a necessity, the legalities involved, and whether this negotiation would affect others in the future. This negotiation was long-term, as Samsung is a major supplier for Apple, and maintenance of a positive relationship was key. The nature of this dispute did not deal with scarce resources, but rather an ideology regarding copyright infringement. It also stems from a place of disagreement rather than transaction. Linkage effects were inevitable, with reports of an increased number of patents under disputes internationally following the negotiations. This may be attributed to the event being extensively covered in the media globally. The power differential does not have a major gap as both parties are tech giants. On the situation involved both parties working with a mediator to find resolutions and a settlement. As noted by Steve Jobs to Walter Isaacson, I will spend my last dying breath if I need to, and I will spend every penny of Apple's 40 billion in the bank to right this wrong. I'm going to destroy Android because it's a stolen product. I'm willing to go to thermonuclear war on this. At this stage of the dispute, the approach towards the negotiation was no longer concerned with interests, but rather power, and ultimately winning the lawsuit to avoid a threatening future in the smartphone industry. As noted by Thompson, it takes creativity as well as problem solving to achieve a successful negotiation, rather than a win-lose situation. In the case of Apple versus Samsung, the evident creative approach is fractioning single-issue negotiations into multiple issues. This creative approach entails counterparts creating more issues than there was originally, which would have ultimately caused the disagreement. This is evident in the dispute, as initially the issue was based on the copying of design and patents, which further went on to highlight several issues. When the verdict was met in 2012, which found Apple to have won over the jury, Samsung appealed this decision based on several issues found. One of them being that the foreman of the jury had failed to reveal that he had been sued by his previous employer, who was Seagate Technology, whom had a strategic relationship with Samsung. Samsung identified this among other issues as a hindering factor of the greater issue at hand. Finally, in June 2018, the patent dispute was resolved 7 years after Apple originally sued Samsung for allegedly copying their iPhone design. In 2012, Apple was awarded $1.5 billion for copied features, such as the grid design of the smartphone screen. In 2016, Samsung appealed part of the award, arguing that patent infringement only involved certain features. The court case went to trial again in 2018, with Samsung arguing that they only owed Apple $28 million. The jury set the award at $539 million, a lot less than the original $2 billion Apple had hoped for, but a lot more than Samsung's desired outcome. Apple issued a statement after the proceedings, stating that the case had always been about more than just money. Legal experts told the Financial Times in 2018 that Apple had little to show from their patent war with Samsung. They stated that the smartphone patent wars were not all that they were made out to be. They didn't block any products from the market, and they barely dented the company's bottom line. They guess that the settlement will have absolutely no impact on the current marketplace.